Mark, back on December 18th, 2023, we did a show that we called Crime of the Century, and it talked about the foundation of the opiate crisis in the United States, how we ended up with this incredible fentanyl addiction problem, fentanyl harm, death problem. And kind of at the root of that, I think you and I talked about Purdue Pharma as part of Big Pharma and as a company that made decisions that weren't necessarily ethical, weren't necessarily right for the American people and for patients. They got hit with a ton of lawsuits, right? Thousands of lawsuits, literally thousands of lawsuits. And these lawsuits were kind of, let's say, grouped together, and they had reached, the company declared bankruptcy. They had reached a proposed settlement agreement. And I think this is actually something that you clued me in on, Mark, a couple of weeks ago. You said, hey, Bill, June 27th, New York Times, check out this article. It was the Supreme Court the Supreme Court looked at this proposed settlement and they rejected it. And why did they reject it? They rejected it because of the liability shield that would have been kind of extended to cover the Sackler family.
Right.
So the Supreme Court said, no, 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 you cannot indemnify yourself from, personally from all future lawsuits as part of this settlement. And that kind of threw a monkey wrench, I guess, in the works. And, the thing stalled. And now we don't know where it's going to go. And I think it's interesting, Mark, because, the Sackler family, of course, the angle they're taking in this thing is, oh, this is holding up the billions of dollars that we were going to release to help in drug treatment and to find solutions to the problem. And now we're not going to release that money quite yet because we don't have a settlement agreement. Well, when you saw the Supreme Court take, Mark, what were your thoughts on it?
I have to say, I was a little surprised for the reasons that you articulated, because we know that the settlement had come to fruition and that these families were looking for some type of satisfaction from the loss of their loved ones. It was a very interesting split. It was a 5-4 decision, but here's what made it really interesting and very unusual. It was actually Brett Kavanaugh who was in the minority on this one, and he wrote a pretty scathing response in the dissents to generally his other comrades philosophically in the court, and saying the same thing you said, Bill, is that, hey, this is going to be holding up payments that are absolutely justified to these families who lost loved ones as a result of the behavior and policies of this company, not just this company, but other companies. So it was very interesting. And the other thing I found interesting about this is that it really goes to a bigger picture. Look, I'm not a lawyer, I'm not a law scholar, but I do have a little bit of understanding about corporations, why people set up corporations, things like this. And it's to have a legal shield between yourself personally and any liability claims against your entity. So this, I don't know how far this goes, Bill, in actually breaking that mold. In other words, where does it stop? If the corporation does not protect the Sackler family in this case, what other individuals can now be personally liable based on this ruling with other companies? I don't have the answer to it, but it's a very interesting
Yeah.
question to ask, I think.
And that's a really interesting question. And down the road, we may see we may see something with Boeing involved with this. Here's a summary of kind of the decision, and then we'll move on, Mark. Protection from civil lawsuits is typically granted to companies emerging from bankruptcy restructuring, as Purdue is. But because only the company and not the Sacklers had filed for bankruptcy, the Supreme Court said the Sacklers were not entitled to the same shield. In doing so, the court agreed with the U.S. trustee, an arm of the Justice Department that oversees the bankruptcy system, which said that a bankruptcy judge did not have the authority to grant such a shield. The government argued that allowing the family that protection would have been done without the consent of future plaintiffs and would so deprive them of due process. So, interesting. It goes back to the drawing board. And from what I'm hearing, they think they will eventually work out a settlement. There will be a settlement. It's just a question of, without that shield, the question becomes, how much are the Sacklers willing to pay? Are they willing to pay less because there's the potential of future lawsuits, right?
Yeah, and if you don't mind, I want to finish with this. Is Kavanaugh accused the majority of rewriting the bankruptcy code and restricting the long-established authority of bankruptcy courts to fashion fair and equitable relief. for mass tort victims. So again, it ties it up in a bow there about what the protections of a corporation give individuals, whether it's civil liability or it's financial protection. I just find it very interesting, and this could have long-term repercussions throughout the country.
Agree. We'll keep watching that one, folks, and we'll let you know what happens with it.